We're now going to move on to a presentation about legal issues around occupational health and safety with a focus on workplace violence and aggression. This is going to be presented by my colleague from Clayton Utes. Let's get the title of Alistair's presentation right. So I'd like to introduce you to Alistair Smith. He's a Senior Associate in our National Occupational Health and Safety Practice, and his title is First Do No Harm, Legal Risks of Occupational Violence in Healthcare Settings. Alistair's going to run this pretty interactively, so I'm going to sit back and relax for a little while, and he's going to be happy to take questions from you as he goes. So over to you, Alistair.
Thanks a lot for that, Heather. Like most lawyers, I absolutely adore the sound of my own voice. But the reason that I'm here today, obviously, is for everyone in this room's benefit. So the way I'd like to run this session is I'll start talking. I'll start talking about sort of what I want to talk about and some of the things that I think might be important. But please pull me up as I go through and ask me any questions that you might have. Challenge me on anything that you don't agree with so that we can talk about it. Or if there's something you'd like to discuss that's within the broad realms of the topic. I don't do fencing disputes. Please just let me know and we can have a discussion about those things as well. Before I though get into the sort of substance of the presentation for today, I guess I wanted to talk to you about a couple of thoughts that I had. I should say, sorry, to those of you on camera, I'm going to be bitterly disappointed if I don't get a written question. So if someone could please send something in, that'd be great. When I was having a think about what I was going to come and say, there's all the technical legal issues, there's the obligations, there's all of that good stuff that we lawyers like to talk about, but what's really important with respect to occupational health and safety law? So I just wanted to start at that point, a bit of a first principles and more of a philosophical look at things. So why do we have laws? We have laws to basically codify what governments tell us our moral obligations are. It's pretty common ground across both sides of politics, and I think most of society, that everyone should be able to go to work and come home safely. The Occupational Health and Safety Act here in Victoria, like its counterparts right across the country, is directed at telling employers, telling officers of boards, that we want you to make sure that your people come home from work safely. Similarly, the obligations that were mentioned earlier that are imposed upon individuals are telling people, we want you to take care not only of yourself, but the health and safety of those people that you work with, and we want you to make sure that those people that you work with, along with yourselves, come home safely and in the same condition that you started in. And at the end of the day, if we're putting the amount of effort that we need to be putting into making sure that our people are coming home safe, we're educating them, we're training them, we have systems in place, and if our people are putting that effort in as well, then we're all going to comply with our obligations. I haven't sort of come here to do the fire and brimstone legal presentation that some of you might have seen before. I think the time for that has passed, and the fact that you're all here shows that you actually have a commitment. I'm more here to explain, I guess, what some of the obligations and some of the risks are. The other thing that occurred to me when I was preparing this presentation was that health is a bit different to many of the other industries that I deal with. I do a lot of work in construction, I do a lot of work in mining, I do a lot of work in petroleum and gas. Those sectors are focused on particular economic gain, and the majority of the risks, while there's obviously human factors involved, relate to things. Explosive atmospheres, gas, asphyxiation, and all those sorts of nasties that can catch up with us. Here, when we're talking about occupational violence, we're actually talking about humans who are significantly unpredictable, and we're talking about humans that we're actually trying to care for. It's very easy to say, that's unsafe, you can't dig up that coal. You can't dig up that coal until you put extra controls in. But when we've got someone with dementia who doesn't know what they're doing, when we've got someone with severe mental illness who's perhaps delusional, when we've got someone under the influence of ice or something like that, and they have a serious medical issue, we feel compelled to help them. So there's a much more significant challenge in trying to help those people while at the same time trying to keep our people safe. There might be circumstances where you need to go, we actually can't help that person because it's unsafe to do so. But by and large, what we're going to be looking at is, okay, how do we keep our people safe while meeting our other moral obligation, which is to actually care for people's health. And that's a much, much bigger challenge. I've advised in the past, in addition to health services, prisons in respect of prison guards, who are expected, often in small numbers, to stop significant violence by some incredibly dangerous people. And I've advised defence, who obviously have a public good as well, which sits against some of the dangerous training that they do. So I guess I wanted to make those observations because as we go through and we're talking about some of these health and safety obligations, I'm going to touch back on some of these issues and some of the strategies that we might use to comply with our legal obligations while still caring for people as we properly should. Okay. I'm fantastic with technology. Which one is it?
There we go.
There we go. So, what is occupational violence? I'm not going to labour on the point, but it's actually always useful to have some sort of statement about what it is that we're talking about. Now, we've gone through this quite a bit this morning. The one thing I just wanted to take from this, and I use the Department of Health and Human Services definition. Someone will correct me if I've got an old version from the internet. But it's just this talk about abuse and threaten. Leaving aside actual physical violence or things that would otherwise constitute an assault, we're talking about some of the mental aspects earlier today. It's important that we pay attention to those because, of course, the occupational health and safety legislation isn't just directed at physical health, it's also directed at mental health. So we actually need to have systems in place to ensure not only that people aren't physically harmed, but that people's well-being isn't affected by these sorts of things as well. The other thing that's worth mentioning in this context is we've had a significant focus today on patient on staff violence, which is obviously a significant issue. There is potentially also patient-on-patient violence occurring in our workplaces, and indeed there is staff on patient violence that occurs from time to time as well. We've seen some well-publicised cases of that over the years. So in this drive to protect our people, which is an incredibly important thing for us to do, we should not forget that we need to manage these other risks that are equally as important. And indeed we have obligations in respect of those risks. What I'm going to talk about, I'll just skip over this slide. I think we've talked enough about the problem, and I'll make some observations about some of the data requirements and those sorts of things shortly, is to talk about the legal obligations. Now, of course, as is my usual practice, I didn't do notes, and I can't read exactly what they say, so I'll just give you the general gist. So I've picked out three. There's a fourth one that I'll mention that was mentioned earlier today, which is also important. But in Victoria, the language focuses on that of an employer, and it requires the employer to do that which is reasonably practicable to protect the health and safety of employees and to protect the health and safety of persons other than employees of the employer at the workplace, which, might I add, would include contractors such as security guards. So we have these obligations to do what's reasonably practicable. Then I would say almost everyone in this room, if not everyone in this room, has a further obligation as an officer of whichever the relevant body corporate is, and whether that's an unincorporated or incorporated body, including government bodies, to take reasonable care to ensure that those bodies don't commit an offence as well. So those are the obligations. I'm not going to dwell on the legal technicalities of it all. What I'm going to talk about is maybe some practical compliance, because if we talked about legal technicalities, you'd all be asleep and it'd be midnight by the time we were done. One thing I will say is just remember that term reasonable. It does mean what is reasonable in all of the circumstances. So we do need to take into account And I'll talk about a prosecution that happened in New South Wales, which will give you a bit of a flavour of the sort of things that might be prosecuted. And there's others here that could comment more on that sort of thing than me, but it does serve as a useful example. So how do we discharge these obligations? The thing about this law is it's great at directing us about what performance we need to achieve. It doesn't so much tell us how to do it. What it says is you need to manage your risk, you need to understand what your risks are and manage them. It doesn't say thou shalt this and thou shalt that, which is a fantastic thing because it actually gives you the freedom to determine what's the best approach in all of your circumstances. Now I've drawn up this little diagram, which again I can't read from this distance, but luckily enough I'm pretty sure I remember what's in there. So the circles around the outside are talking about, I guess, systems and processes, and the circle in the middle is talking about cultural change. Because ultimately, for you to achieve the outcomes that you want to achieve, you need a combination of both. Culture obviously is important, as we've talked about, with respect to things like reporting. But it's also important that people buy into what the systems are. They understand what the systems are through training. They actually see the results of the system. There were some comments earlier today about the fact that one of the reasons for underreporting, I think it was in the first presentation, was that people report and then they don't see anything happen and they don't understand what's happening. Why are you going to report something if you don't know what's happening? You're banging your head up against a brick wall. It doesn't work. So you need to have a culture, but to have a culture you need systems. So there's a question as to which drives which, whether systems drives culture or culture drives systems. I'm not going to attempt to resolve that. Rather, I'm going to suggest that you probably try and implement both at once, and you change both at once and they grow together. So you need to understand the problem. We've heard again and again today in respect of data that we don't have sufficient data and that these incidents are significantly underreported. That's a cultural issue. It may also be an issue with difficulty of reporting. Certainly that's what the Auditors General's report that I read said. There's probably an issue with follow-up. So let's make reporting easy for people, and when we get the report, we do something about it. So that's where appropriate investigating incidents, particularly those more serious incidents, but also actually using that data to inform the way that we work in the future. Because going back to the law for a second, if there's something we knew about and we had the data and it told us that we had a particular problem and we've chosen not to address it, we're going to have a very hard time standing up in front of a magistrate and explaining why it is that we failed to address it. And of course, there's a moral imperative there as well. So then we've got that data. What do we do with it? We know there are issues. What do we do? Hazard identification, risk assessment, and the implementation of controls. And that's something that each and every one of us does every day. Some of my colleagues that work in safety, talking my non-legal colleagues, like to mystify risk assessment and talk about all the structures and things that you need. We do risk assessments every day. If I was to walk over and sit on one of those chairs, I might walk over and I might have a look at it and make sure that it's not about to fall off the back of the stage, that it looks sturdy, that it's suitable. That's a risk assessment I've done in my own head. Yes, it's not formalised. Yes, it's not written down, and for our higher order risks, we absolutely need to do that. But it is not a special skill. It is something that each and every one of us can do, and it's a process that each and every one of us can learn. My point with that is then, so we've got those natural skills. The statute actually tells us what we need to take into account. Statute tells us that we need to eliminate risks, and if we can't eliminate hazards, and if we can't eliminate the hazards, we need to reduce them. Now here, when we talk about occupational violence, those hazards are people. So unless we get the Terminator along, we're not going to eliminate them. So instead, we need to actually do something to reduce those risks. I'm not going to go through the hierarchy of control and all that sort of thing for today's purposes. It's not necessary. But what I will say is that the higher order control, the more separation and the better controls that you can get, the better off you are in being able to show that you've complied with your obligation. So we've got that. We've got implementation. So we need to actually implement these things. There's no good creating a system and having the system sit on the shelf. In fact, in many respects, again, having a system that you don't use is actually probably worse than having no system at all. Because if you have a system you don't use, what you're saying is, I understand my obligations, I understand the risks, I know what the problems are, and I've got a system for it, but I couldn't be bothered implementing it. Now, if you think about that for a second, that's a terrible, terrible message to be giving anyone, because you know what the problems are, but you're not doing anything about it. So I'm almost out of time. I got nowhere near through what I'd planned to get through, which is unsurprising. I think I'll just finish on a quick note about a case from New South Wales, the name of which has just escaped me. But effectively what happened in this New South Wales case gives it an illustration of the things that shouldn't happen and how prosecutions can occur. In that matter, there was a person who was working in a residential care facility. This facility was a respite facility by and large, but they had a couple of permanent, or they had at least one permanent resident. This particular permanent resident was a male. He was about 20 years old. He had some cognitive disabilities. He also had schizophrenia. He'd been diagnosed as a schizophrenic, and he'd had some delusional episodes in the past. Over Christmas, he was left alone. He also had a record of some sexual assaults against other patients within the facility and potentially against carers. And he was left alone with a female carer. They were the only two people in the facility over Christmas. The facility didn't have any policies or procedures for dealing with mentally ill patients, and it didn't have any policies or procedures for dealing with occupational violence. It didn't have panic alarms. It had 2 landline telephones, and this is an old case. It was before everyone had a mobile phone. Had 2 landline telephones. The patient in question was showing some delusional behaviour in the afternoon. That behaviour worsened over the course of the day. The carer took him for a time to another care facility to have an afternoon tea and used some intervention strategies to try and control his behaviours better. Following that, they went back to the home. So no one at the other home said, oh, hang on, maybe you should stay here, where we've got some more staff and some more people, because this behaviour has been continuing to be exhibited. So they go back to the home. The carer becomes deeply concerned about her position and locks herself in the bathroom while she has a bit of a think about what she can do. Fortunately for her, while she's in the bathroom, she opens the bathroom window so she has an escape route if she needs it. She then decides that she will telephone someone, so she has to go back to one of the landline telephones. She opens the door and this chap's there, and he starts strangling her. And he continues to strangle her. Fortunately, he decides that he needs a knife. He lets her go. He says something to the effect of, I need a knife, and starts to wander off to the kitchen to get a knife. This is not going to end well, save and except for the fact that, thinking quickly, the care worker escapes out the bathroom window, only barely. She lost a shoe in the attempt because this chap saw her trying to escape and went back after her. In that case, in New South Wales, her employer was convicted and fined in the order of $90,000. The point I raised from that is simply this: you look at the multiple failures in there about the control. So it's not that this guy shouldn't have been cared for or looked after, but looking after a patient who displays that level of risk ought only be done when there are sufficient controls in place to protect the person doing the looking after. And with that, I'm out of time, I think.
Thank you, Alistair. Did we get any questions from our rural colleagues? No. Any questions here from the floor? Yes, thank you. Do we have a microphone? Thanks.
Dale Fraser from Ballarat Health. Just a question on our legal rights to exclude people from our facilities, whether they be under active treatment or visitors to our facilities. Can you perhaps just comment on what our rights are and how we might go about making that far easier to achieve?
Yeah, absolutely. So the short answer, like all good lawyers, is I don't know immediately. I'd have to look at a book. Just to add to that, though, I was actually giving this some thought this morning. So it will depend upon the way in which they're excluded. So in the first instance, when you have security guards, for example, excluding someone, whether they're using reasonable force, if they need force to exclude them, there will be issues, I would imagine, about getting orders from the court, if necessary, to keep someone away from a property, so that that may or may not be possible. I'm not entirely sure. Then there's the issue about who makes the decision. There's other liability issues that come with that. I mean, it's a multifaceted sort of issue, in the sense that there will be certain service obligations, I imagine, that the hospital has, and there will be certain ways of, under the legislation, under the health legislation, things that people have to do. So account will need to be taken of all of those things in making a decision about excluding someone. So that's work, though, that should all be done before we're making decisions to exclude someone. So what you would ideally do is you'd have someone look at all of that, and you develop a policy or a procedure which says, if we're going to exclude someone, here's the things that need to be present so that we can make that decision. And you've got then the decision-making guide to make it easy. So short answer is I can't tell you all the answers. Long answer is someone needs to consider all of that and basically develop a guidance or a checklist and some training for it.
Thank you, Alistair. John.
Yeah, John Raza from Latrobe Regional Hospital. I'm just wondering, in relation to security officers, which you just raised, in terms of hospitals, I guess they used to employ security officers. Now many of them are contracted, but there's still quite a few hospitals that employ their own staff. What are reasonable expectations of security officers putting themselves in harm's way in order to, particularly in EDs, because a lot of times they were hired just to make sure that doors were secured after hours, the parking was controlled, all those sort of things. But now the level of aggression, I suppose, has gone up. So what can we expect of A, employees who are security officers, and B, of contractors who may be hired to achieve a certain outcome?
It's a fascinating question. I think what it comes down to, and I don't think there's really a distinction to be drawn necessarily between employees and contractors. I think the more important question is, are we hiring the right people with the right skill sets to be security officers, depending on the nature of the role? So if you have someone who's hired in more of that traditional custodian role to go around and check that doors are secured and those sorts of things, you'd have certain expectations for someone doing that role, which would be, it's a fairly basic skill set. If you're hiring someone to be in an emergency room in an area where you have significant problems, you'd want someone that was more skilled and more capable. Now, the state, I don't think, has the expertise necessarily to be A, training, and B, hiring those people. So you'd be looking at expert security providers to provide those individuals. But then I think there's a level of training over and above that, because they're not nightclub bouncers, of getting the right individuals who are trained properly, but who also appreciate the environment. So I would have thought the obligation is probably a risk-based obligation to look at what the risks are and what skill sets you need from your security guards to adequately handle the risks in a particular environment.
It's difficult, isn't it, to know what the standard is, I guess. And the standard is as far as is reasonably practicable, and that's always, in a sense, it's looked at in retrospect. That's when you're tested on it, isn't it? But I think the point of, there's a lot more information sharing that is going to be available between health services as to what a reasonably practical approach might look like. Yeah. So hopefully people can share that. One last question, thank you.
Loretta Shields from the IND Hospital. The definition that you put up, the department definition, was fairly broad. Would that include staff to staff?
Look, I would have thought so, and if it doesn't, it probably should. So, and one of the points I made earlier, and I think it's a really, really important one, is that yes, we're focused on patient-to-staff occupational violence today, and that's an incredibly important issue, but there is no excuse, particularly for staff-to-staff violence, or staff-to-patient violence either. Ultimately, everyone, the obligations are in relation to everyone at the workplace, therefore it doesn't matter. And there are, I think there's a bullying code of practice here.
It's not a code of practice, it's just guidance.
It's guidance. So there's bullying guidance that WorkSafe publishes, and of course there's those mental aspects to the duty that we're talking about, plus the physical aspects. It's never okay. It doesn't matter if it's staff to staff, patient to staff, staff to patient.
I guess just... Oh.
Question is, what about family to staff, relatives to staff? It's everyone in the workplace, isn't it?
Yeah, absolutely. When I say patient to staff, I should actually be broader than that. I should say public to staff, because that's the reality. As specifically, you know, when people are upset where they don't think their family's getting appropriate care or those sorts of things, absolutely falls into the same category. And of course, many of these things, not everything that we describe in that definition, but many of these things are crimes. It's quite appalling from my perspective, what I heard recently or throughout this session, that the police force don't actually take it seriously. But these are crimes. Assault is a crime. You know, it's just unacceptable under the law in any way, shape or form.
One last question, I think, Loretta, you wanted to come back?
It's just more about the reporting that we need to...
Just pop the mic up, thanks.
I guess my point was just about reporting too into the future. If we're looking at benchmarking, that we get the definitions right, because we are all reporting on bullying and so forth. So,
yep.
Okay, thanks.
Yep, and so that would be a request for standardised definitions and perhaps templates. And I often think on boards and at senior management, we all have a very clear sort of set of reporting around financial performance of a health service. We all do the same. We all know what's to be done around some of these areas. Getting more commonality would be good, wouldn't it? And is being worked on, obviously. Alistair?
Thank you. Yeah,
okay.
I agree.
Agree. Okay. Thank you. Alistair, thank you very much for your presentation.